So in this video, I want to break down what is currently going on in the Rhode v. Bonta California ammunition ban case now that the Supreme Court has ruled in Bruen. So let's talk about this. But real quick before we jump into this video, if you think we shouldn't have background checks to purchase ammunition, go ahead and hit that like button and subscribe. Also, I want to thank one of the main sponsors of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, in this video, I want to break down the Rhode v. Bonta California ammunition ban case and what is happening now that the Supreme Court has ruled in Bruen. Rhode was one of the many cases that was on hold in the Ninth Circuit, waiting for the Supreme Court to rule in the Bruen case. And now that we have that decision, this case is once again moving forward. Now, if you're not aware, Rhode v. Bonta deals with the state of California's restrictions on the purchase of ammunition and also background check systems that you must go through to purchase ammunition in the state of California. This provision was passed through Proposition 63, which requires purchasers of ammunition to undergo one of two background checks to confirm they are legally able to purchase ammunition. There is the basic eligibility check and also the standard eligibility check, both of them coming with their own different fees, but essentially what they are is they are background checks for you to purchase ammunition. This law in California also restricts the ability for someone to be able to purchase ammunition online and have it shipped to them directly to their home. Instead, in California, all ammunition purchases, even online purchases, must go through an FFL where a background check is run on you as well. This also leads to increased fees every time you purchase ammunition online and have it sent to an FFL, because the FFL will charge an additional fee to transfer that ammunition to you, and also you have to pay the fee to run the background check. So this whole scheme in the state of California adds a ton of fees, a lot to the process, and also requires that you have to go through a background check. So that is essentially the law in question in California and what is being challenged in Rhode v. Bonta. Now, in April of 2020, District Court Judge Roger T. Benitez, or Saint Benitez as he's known in California, reviewed the Rhode v. Bonta case. On review of this case, Judge Benitez implemented what can be best described as a version of text as informed by history. He described this as a simple Heller test. He stated, Heller asked whether the law bans the types of firearms commonly used for a lawful purpose. He reiterated, it is simply a hardware test. Using the simple Heller test, he stated, it is obvious that California's background check laws that de facto completely block some law-abiding responsible citizens from buying common ammunition are unconstitutional. He pointed out that under the Heller test, the review could end at this first step and he wouldn't need to go any further. However, he also went further just in case and also went into the historical precedent for these types of restrictions. He also went on in his order to find that an ammunition background check has no historical pedigree. In fact, he stated, a background check required each time ammunition is purchased has never been implemented before. The fact that Benitez applied text as informed by history is important because that is the standard that the Supreme Court said all Second Amendment violations must now meet under this new Bruen decision. Thomas in the Bruen opinion stated that, today we decline to adopt the two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So the Supreme Court's opinion marked the end of the Ninth Circuit's two-step approach and the start of text as informed by history, like which Judge Benitez just used in finding that the California ammunition ban is invalid. Now, after his ruling, the state of California appealed the decision up to the Ninth Circuit. In doing so, they also sought and were granted an emergency stay by the Ninth Circuit. An emergency stay essentially put a stay on the Judge Benitez ruling and prevented people from being able to purchase ammunition online or without background checks. And this is what led to the whole ammo day issue and why some people call this case the ammo day case, because essentially the laws in the state of California were lifted for only about a day period of time before the Ninth Circuit issued that emergency stay. So currently right now, the only thing preventing ammunition purchase without background checks or ammunition purchases online directly to your door is that Ninth Circuit stay. That stay was granted on the basis that the state of California was likely to succeed on the merits of the appeal because of that two-step approach. If you look at the granting of the stay by the Ninth Circuit, they said the main basis that they issued that stay for was the likelihood of success on the merits, and that is one of the factors that they look at if they want to grant a stay or deny a stay. And they said that they are primarily granting the stay to the state of California because of that likelihood of success on the merits, and that whole likelihood of success on the merits is based on the two-step approach that the Ninth Circuit had leaned on the past. But that two-step approach is now invalid, and the very basis that the stay was granted is also invalid. So the stay is now completely open to challenge, similar to what we saw FBC do in the Miller v. Bonta case. FBC challenged the stay in the assault weapons ban case, Miller v. Bonta, because it was granted on the same basis, that two-step approach and the likelihood of success on the merits, and they argued that that is now invalid. I would expect that there could be a motion here in the Rhode case as well, filed to lift the stay from the Ninth Circuit because that whole likelihood of success on the merits is no longer valid. Now, procedurally, Rhode is a little bit different than Miller and some of these other cases because Rhode has already been heard and oral arguments were held on November of 2020. But since then, it has been on hold and we have been waiting for the three-judge panel to issue their ruling. So oral arguments were held. This case has made it through the entire process in the three-judge panel, and we were simply just waiting for them to issue their order, but they ended up putting a stay on it. Well, after the Supreme Court's ruling in Bruen, Rhode is now moving forward, and this is the order from that three-judge panel in Rhode. The panel's previous order, issued March 19, 2021, holding this appeal in abeyance, pending issuance of the mandate in Duncan v. Becerra, is vacated. The parties are directed to file supplemental briefing in light of the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruen. Defendant appellant's supplemental brief shall be filed no later than 30 days after entry of this order and shall not exceed 10,000 words. Plaintiff appellee's supplemental brief shall be filed no later than 30 days after the defendant appellant's supplemental brief, and it shall not be exceeding 10,000 words. And then they say that the reply shall be 21 days after that and shall not exceed 5,000 words. So essentially they're moving this case out of the holding pattern, and they want completely new briefing, new arguments in light of the Supreme Court's recent ruling. So essentially they're going to take a fresh look at this case. They're looking for supplemental briefings. I don't believe they're going to hold new oral arguments or anything like that. They just need new arguments in light of the Supreme Court's ruling. So here in the next month or two, the new briefing and voting will be submitted, and the panel will finally get to decide how they will rule in this case. I would also expect to see additional motions to lift the stay or for arguments that the three-judge panel should simply grant summary affirmance of the Judge Benitez ruling down below in light of Bruen because, again, Judge Benitez ruled in light of text as informed by history even before the Supreme Court said that that's what courts are supposed to do. And I say even before, and that's not necessarily true because if you look at Heller-McDonald, simply what Benitez did was apply Heller-McDonald, but lower courts like the Ninth Circuit were not actually doing that. They were using a completely different standard, which it took the Supreme Court finally saying that is the wrong standard. Stop using that. Actually use Heller and McDonald. Now, I would say the makeup of this three-judge panel is not super favorable. There are two left-leaning judges, one of them actually out of the Second Circuit who's sitting in the Ninth Circuit right now filling a spot. So again, not super favorable makeup, but I do like that Judge Bumate is also on this panel. Judge Bumate, personally, I really like the way he writes. I like the way that he thinks about the Second Amendment. I like the way that he supports the Second Amendment because he was one of those justices or judges in the Ninth Circuit who was advocating for text as informed by history, while other district court judges or while other Ninth Circuit judges were arguing for the two-step approach. So Judge Bumate gets it. He understands the precedent. He understands the Second Amendment and how it should be applied in these contexts. So I like that he's on this panel, but again, the makeup is not super favorable. So a lot of you were asking, where does the California ammunition ban currently stand? And I think that should give you a good idea of where this case currently stands and where it's going. If you guys have any questions, go ahead and comment down below and I'll try to answer best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.